Everybody to the July 6th Planning and Zoning Commission meeting. Welcome everybody. The first thing we'll do prior to the approval of minutes is we'll just do a roll call for the commissioners. So I see, I'll just go ahead and just start. Art, are you here?
I'm here.
All right, Rebecca?
Yes.
Harry?
I'm here.
John?
Here.
I don't think Holly's here. Holly, have you made it in? All right. Clarice?
Here.
Richard? I see Kevin here, and obviously I'm here. So that's everybody. So we are missing Richard and Holly at this point. And Hunter, you'll give me a heads up if they come in, I assume.
Yes, sir.
All right. First item on the agenda is the the minutes from the June 1st meeting. Commissioners, y'all have had those for about a week. Are there any corrections that need to be made? If there are no corrections, I will entertain a motion.
This is Art. So moved.
I've got a motion to approve. Do I have a second?
This is Harry. I second.
All right. Any further discussion? All in favor say aye.
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 Any opposed say nay. All right, Ken, if it's okay with you, I'm just going to do voice motions, but if I get any nays, I'll then do a roll call. Is that okay?
Yes, sir.
Okay. All right. We're going to pull something up on the agenda real quick since we have an engineer here. It shouldn't take but just a second, but we've got item F we're going to start with. It's an AT&T U115211 review. They want to put 3,729 linear feet of underground optic cable from Twin Beach Road to County Road 13. I know the people out in that area will be very happy. Who will present that?
That will be me. This is Samara Wiley. Can we see the PowerPoint?
Yes, we can, Samara. Thank you.
Okay. So again, this is UR 20.04. This is AT&T at Twin Beach Road. Again, this is a utility review for approximately 3,729 linear foot of underground fiber optic cable. The project will run along the north side of Twin Beach Road from 8345 Twin Beach Road to County Road 13. Here is our area of work along with our zoning map. And then we also have the aerial view. This is the drawing of the location, so it's very near to Pirate Drive, all the way out to County Road 13. Again, these are just some general comments in regards to the review in terms of the requirements of the proposed construction. It was reviewed by the Planning Department as well as Public Works Department and Utilities Department. The applicant has coordinated with the right-of-way inspector with regards to potholing requirements and elevations of the crossings that will be required at the end of the project. No work shall begin without a permit issued by the City of Fairhope Building Department. Again, just general comments in regards to the business license of our contractors and subcontractors. It shall comply with the wetlands ordinance, the red soil ordinance, and the erosion and sediment control ordinance. State and federal permits shall be on file with the City of Fairhope, and then the applicant shall provide as-built profiles of the installed lines with the proper dimensions for the drawings. Staff's recommendations is approval subject to the following conditions, and I will read these for the record. Consultation with the city's horticulturist, Mr. Paul Merchant, to determine if the required depth of bore must be increased so that no trees are impacted by the project. The contractor is responsible for any damaged trees. Number 2, to edit the note on drawing 4 of 11 to reflect 36-inch separation from all drainage and utilities. Number 3, at all street crossings, conduct potholing to determine exact location and elevation of existing utilities, reflect the exact elevation of utilities and GPS coordinates of the pothole locations on a set of as-built drawings. An additional right-of-way permit must be required for the potholing procedures. And lastly, memorialize the follow-up activities below required by staff and the applicant. The applicant shall submit as-built drawings to the construction inspector reflecting the requirements of condition number 3. And then upon satisfactory review, the approval of right-of-way construction inspector as-built will be submitted to the utilities GIS technician for inclusion in GIS utility maps as needed. And that is all that staff has.
All right, thank you, Samara.
Mhm.
We tried to catch you off guard switching that around, but you did a great job. Thank you. Is there anybody here that wishes to speak on behalf of AT&T?
I'm Wade Mitchell. I'm the engineer for the project with AT&T, but I don't have any comments other than what Samara
Okay.
discussed.
Thank you for being here. This is not a public hearing, but would anybody from the public have any questions about this? Well, if not, commissioners, do you have any questions or concerns about this? Any questions for either the AT&T representative or for Samara? If not, I will entertain a motion.
Yeah, this is Art. I would move case UR 20.04 AT&T Twin Beach Road utility review that we approve subject to staff recommendations.
I've got a motion to approve. Do I have a second?
This is John. I second.
I've got a motion, a second. Is there any further discussion? Well, all in favor, say aye.
Aye.
Any opposed, say nay. All right, the motion passes unanimously. All right, next item on the agenda, we're moving back to the top. SD 20.17, public hearing, discuss some items that we have discussed in prior meetings that is now given to us in a form for adoption. Is Buford going to go over that?
I will. Commissioners, can everyone hear me okay?
Yes, sir.
All right.
Yes.
Has my shared screen, can everyone see my shared screen
Yes.
now?
Yes.
Okay, Commissioner, so we'll jump right into this. We've discussed this before. And before we start, Commissioners, what I'll call your attention to this. You'll notice on each slide, the item number is in red text. That matches up to the item number in the resolution. And so, just so you'll know how this unfolds, some slides may have 2 items on them, and then some items may go through 2 slides. So if there's a question about an item that the Planning Commission may want to pull and not include in their approval, then we can just simply reflect the item number. So I just want to describe that going forward. The first item, Commissioners, this is just simply adding a date of last amendment to the cover of the subdivision regulations. Very straightforward. Next item, Commissioners, this is adding some wording to the definition of a lot. And what that does is that helps us in terms of distinguishing a lot from a parcel. And so this is some wording Mr. Watson helps with that helps that definition. And Commissioners, here, item 3, you'll notice the item in blue, number 2 down there, is an addition. And so what this does is that if a PUD is created, and if as a part of the PUD, the applicant conducted their own community meeting prior to the creation of the PUD, this allows them to not have to repeat that process again for the subdivision that comes along with it. And Commissioners, you'll note up in item 1, we had this wording, except as specified in 2 below. That may not be in your actual resolution of adoption, so we want to incorporate that, and that can be reflected in your motion. So just a simple thing here, I'll remind the Commission about that when we get ready for a motion.
Quick question, if we have questions, would you like to interrupt and address those, or wait till you get through and try to retrace our steps?
That's fine, and what we can do is, if it sounds like it's going to be a long discussion, we'll kind of jump in. But yeah, if someone has a question, they can jump right in.
I got a quick thought on that one. Maybe just amend that last number 2 to if the meetings happened within the last 2 years. So if it's a PUD that was approved 17 years ago, maybe we do want a community meeting.
That's a good point.
Okay, yeah, that sounds fine.
Okay.
That sounds fine. I think that actually could help us. I'll tell you what, Hunter, if you'll remind me.
Question as well.
Okay, Rebecca, go ahead.
My understanding, I guess the item before this, when you're changing the language from it, a lot that fronts on the public right away to will generally front. Are we just building in flexibility, or is there a problem? Are we trying to encourage things that don't play on the public right away? I didn't understand where we were going.
Yes, and that'll be explained that'll be explained a little bit better as we get through the rest of the amendments.
Rebecca, this is Ken. That language is driven by the fact that at times the commission has relaxed the technical requirement that all lots run on a publicly maintained and paved street, and in part ties to proposed revisions which would expressly allow for that in certain circumstances. So that's the basis of that language.
Okay, thank you.
Okay, we ready to move on?
Sure.
Okay, and so item number 3, Hunter's going to remind us about a revision we want to verbalize if it's a pleasure to the Planning Commission to accept it. Then item 4, this is just a routine change, and Commissioners, so you know what we're doing here, by making the DBH of trees 20 inches instead of 24. 24 is what's currently required. The tree and landscape ordinance requires that it be 20 inches. This allows the 2 documents to agree with one another. You're going to see this a couple times as we get through the revisions. Okay, Commissioners, this is going to be our first really big change, and so if you'll call your attention to item number 5, what this is doing is this is eliminating the ability to use a performance bond for street trees and sidewalks. And this is going to be further reinforced by another change you'll see on another slide. But I just want to make certain that we call to the attention of the Planning Commission, this is a pretty major change, and I'll have some additional information as we go along that reinforces this. Number 6, I'm sorry.
You could let me jump in here. And I wish we had a chance to iron this out before we got to the meeting, but due to dodging COVID and the holiday last week, we just didn't get it done. But I think in A, I propose we retain the language that, I know it's in the later provision you just referenced, but in this provision is encountered before you get to that part of the regulations. I propose that we leave A in and only have it say installation of all required improvements as determined by the city's general superintendent. In other words, we state here, like we're going to state in the follow-on provision, that installation of all improvements is a requirement to move to final plat approval.
Okay.
So I know we're proposing these for adoption tonight, and then holding some others of a few others for future consideration. I don't know whether the commission wants to put this one in that cat, because we can't act on any revisions we come up tonight. We can't act on them tonight. The actual version to be adopted has to be published. So we could go ahead and make this partial change as you've got it, or we can put this in the stack to be addressed maybe next month when we can get that language in there.
Well, Ken, I don't object to since we cannot modify this. When we get, I'll tell you what, Ken. Let's run through the whole presentation, and then if the Planning Commission has a comfort level with allowing it, I agree with your wording, because I'd rather act upon this. This is something very, very important that we need to get going if we can. So I'm fine with that, Ken.
Okay. Well, if you really wanted acted on tonight, as I say, essentially the same provision comes in one we're going to discuss in a few minutes.
Okay.
But so we could go ahead and go forward with it, but when we come back for the other revisions that aren't to be voted on tonight, let's revise this one again to put that in there.
All right. So what we could do, Ken, is we could pull number 5, but I think the other one is in the 20s. We could proceed with it.
Oh, okay. You go with item 6, but hold item 5.
Right. But
Okay.
but the one further down, we could go. We'll address it when we get to it. How about that?
Okay, I'm with you.
All right. So we'll add that to our list. Commissioners, let me describe number 6, and then I'll pause for a second. Number 6, Commissioners, is a routine edit that captures what we're doing, but is not in the subdivision regulations, requiring shape files. Okay, we'll move on. And Commissioners, here, item number 7, what this does is it just improves. We use terms without properly defining them. This cleans that up, where any other public infrastructure, here and after streets or public infrastructure, what that does is it allows us to properly use the term infrastructure. We use it colloquially. This allows us to use it correctly. Also, you'll also notice the replat shall otherwise, talking about replats. This is clarifying a replat versus a subdivision. Replats are administratively approved. I sign them all the time. But what this does, it makes it very clear that in a replat scenario, we're applying the lot standards of Article 5, and that's basically it. Then, and we talked about this last time, that last sentence, additionally, a replat may be required by the planning director to resolve discrepancies between lots of record and tax parcels. We have that from time to time. It comes up in the building permit process. This gives us clear authority to require that if it's needed. Okay, we'll move on. So item 8. And so what this does, Commissioners, is that now the use of public infrastructure, here's where it agrees with where we defined it on item 7. Okay, item 9. What we're doing here, Commissioners, is bolstering one of the requirements. So if you notice in E right there, the blue text, item number 9, notwithstanding the proposed subdivision may satisfy the technical objective provisions of these regulations, the Commission has discretion to deny a subdivision if there's any articulable, rational basis for a determination that the proposed subdivision otherwise endangers health, safety, or welfare of persons or property. And then that word within the planning jurisdiction of the city is a redundancy that is not needed. So that is a redundancy that may appear in your resolution. So this just bolsters the wording in the event of a denial by the Planning Commission.
Just not to nitpick, but how does property have health, safety, or welfare?
Well, and Commissioner, that word has already in the subdivision regulations. We're adding of persons or property.
Okay, so it currently just says of property. I just always understood health, safety, and welfare is the health, safety, and welfare of our community.
Well, and we're like I said, we're bolstering the wording there.
Okay, if it doesn't have a legal repercussion, then it's not really an issue. It just property. I guess you could say property has health. Okay, I'll leave it.
Okay, and then, so commissioners, the next couple of items, this is item 10. This is just simply clarifying the usage of terminology. What we've discovered is that the word green space and open space have been incorrectly used interchangeably. What this will do is replace the word open space or open spaces with green space, so that way the definition is what it needs to be when we're evaluating a development according to green space. So item 10 basically is adding green space, removing open space. Item 11 is essentially doing the same thing, but we're also bolstering the definition of green space, making it very clear how it's calculated, and then once it's calculated, that it's applied to the entire development. So, shall be calculated based on a net density of a subdivision and applied to the gross area of the subdivision to determine the required green space for the subdivision. And that's been a clarification that the engineers have asked. Then, as you see here, again, replacing open space with green space. And number 11 continued. What we're doing here is making it very clear. Suppose you had a 3-unit multiple occupancy project on a large piece of acreage. Technically, they would not have to have green space. So that this sets a floor of 10% green space if its density is less than 3 units per acre, which is possible if you had 3 units in a big enough piece of acreage. Also, this makes it very clear that this applies to mobile home and manufactured home developments. So that's 11. Number 12, again, clarifying green space. Now, commissioners, what this will do is that currently, and this is one of those things that you discover as you begin reviewing cases, that a green space, what this basically does is that if you want to count green space using a wet holding basin, then that's fine. But we just don't believe that allowing green space for a dry holding basin is beneficial to a development. So what this does, it makes it very clear that you can count that if you have a 3-to-1 slope. And then we make it very clear that you can count 30% of the surface area of the wet holding basin at its static water level. So the idea is that if you have a wet holding basin that is an amenity and meets this criteria, that's fine. This would basically prohibit the use of a dry holding basin for green space, which is not useful to a development. And item 13, what this does, commissioners, is makes it clear that sometimes because we have developments along streets or roads that have a highway construction setback, the subdivision regulations don't allow you to place green space adjacent to a roadway of a certain capacity. But what this makes it clear is that you can have it adjacent to the highway construction setback because it won't be next to the road. It'll be next to the highway construction setback. And then what we've done, the rest again, is clarifying open space versus green space. Commissioners, item 14 is basically throughout table 4-1, replacing open space with green space, and that's throughout. And we won't show you every instance of that, but this would replace it throughout. Item 15 involves green space maintenance, again replacing open space with green space. Number 16, commissioners, again, replacing 24-inch DBH with 20-inch DBH, a routine edit. Same thing for item 17 under significant trees. Replace 24 with 20. That way the subdivision regulations agree with the tree landscape ordinance. And commissioners, item 18, so Ken, so if we can proceed with this one. So this eliminates this provision. The developer may have the flexibility to construct sidewalks within 2 years of final plat approval. This basically requires that at final plat, you must have all the sidewalks installed. And commissioners, I have some photos I'll show you in just a moment to kind of illuminate why we need this. This has become a major problem, mainly because of Americans with the Disability Act compliance. And I think that the time this may have originated in the subdivision regulations, that wasn't maybe as much a point of emphasis, but it's certainly a major issue now. Item 19, Commissioners, this is just adding some clarifying language about sidewalks. And so what this does is this will clarify and provide the Planning Commission with review authority, both staff and Planning Commission, with review authority regarding sidewalks, so it's not a waiver request every time. So you notice item A, sidewalks not required to be installed where lots front on or have access to existing roads or streets, and that authority has prohibited the installation. But in such event, the Commission may require the installation of sidewalks along the margin of the lots adjacent to the right-of-way. So not on the right-of-way, but adjacent to it. Or the Planning Commission can do B. If the Planning Commission shall require sidewalk easements along the margin in lieu of installing the sidewalks. And so this becomes a matter of staff and Planning Commission review based upon the application. We either require them adjacent to but not on the right-of-way, or require a pedestrian easement, a sidewalk easement, to allow them to be constructed in the future. This eliminates those waivers because now it's something within the Planning Commission's authority to review. Okay, Commissioners. And so lot access, I'm just going to read the whole thing to you here very quickly. You notice that we have some introductory language that allows it to work, but basically the Commission in its discretion, but is not required to, may but is not required to, allow deviation from this requirement where such frontage and access to each lot is unattainable due to unique and extraordinarily unusual characteristics of the property. So what we're talking about are lots that do not front upon a paved, publicly maintained road. Again, that's a common waiver. This gives it review authority to staff and the Planning Commission. So picking up deviation will not be allowed where it appears to the Commission that the deviation proposed in whole or part for the purpose of reducing the development costs or increasing density. In allowing such deviation, the Commission will require a creation of an easement at least 30 feet in width to provide for safe and convenient access for ingress, egress, utilities, and public services. So again, gives us, staff and the Planning Commission, authority to act upon this as a review item. Commissioners, this is a super simple, item 21 is a super simple revision because asphalt is not 150 pounds per square yard to get 1.5 inches. You must have 165 pounds per square yard. Okay, Commissioners, so item 22, this revision, or as elsewhere provided for in these regulations. So that ties back to what we saw originally, the power that this gives the Planning Commission to either require the sidewalks in the margin along the right-of-way, or not require them but allow an easement. Again, Commissioners, item 23, this is making it very clear that we require Esri ArcMap shape files for piping and various other drainage systems. This item 24, Commissioners, what this does is it revises the wording to comply to basically now incorporate by reference the Alabama Society of Professional Land Surveyors document standards of practice for surveying in the state of Alabama as far as marking property corners. The current requirement requires every single point to have a concrete monument, and with today's technology as contemplated by the Society of Professional Land Surveyors, that's overly restrictive. Commissioners, item 25, this makes it very, very emphatic. The subdivider shall be responsible for providing all required minimum improvements in the subdivision. This shall be accomplished by full installation of such improvements before the final plat is submitted to the Planning Commission for approval. The predominant effect is you must install street trees, you must install sidewalks to attain final plat approval. And Commissioners, item 25, again, is talking about shape files and videos and various things that we are already getting, that we're already requiring, but it's not clear in the subdivision regulations that these are required. This adds it to the subdivision regulations. And finally, Commissioners, And this is the waiver standards. What this additional sentence hits, the additional sentence here, except where these regulations elsewhere provide for a waiver as to a specific matter, waivers. So in other words, when a waiver is required, they request a waiver. But where it is an item for review by the Planning Commission, as we've seen, then a waiver wouldn't be required. It would be simply a matter of review and recommendation by staff. And Commissioners, just to show you a couple of photos, here's a subdivision that attained final plat in 2007. And you can see the gaps in the incomplete sidewalks. Again, 07. Again, 07. Here's another subdivision that was approved, that final plat was attained in 2015. And so gaps, this is back to that subdivision we saw a moment ago that was approved in 2007. Final plat was in 2007, and this kind of calls out with balloons the gaps of incomplete sidewalks. Here's another that was approved in 2015. Another view of one from 2015. You can see where home construction has occurred and then gaps in sidewalks. Here's one that attained final plat in 2013. And so what's really interesting here is you have entire boulevards without complete sidewalks. Similar situation, a boulevard with incomplete sidewalks. Commissioners, here you actually have an amenity. You actually have an amenity area that is not connected by sidewalks. Then it's great to have the amenity, but it's not connected with sidewalks. Again, a boulevard with incomplete sidewalks. And Commissioners, let me say this very quickly. We're not criticizing a developer or a contractor or anything to that or anything of that nature. Those developments were approved. The Planning Commission granted them final plat approval, and they were approved by the standards of the time that they were approved. But the effect is that, some in case several years later you still have street trees and sidewalks not installed. And because of the ADA requirements and some of the issues that we're dealing with that there's simply not time to discuss tonight, we really need this request. I provided for you here that the Planning Commission may wish to enforce the sidewalk street tree installation requirement on some developments for which preliminary plat has been granted but are under construction. So the list before you here is not exhaustive, and that's something we can work through whenever they come in for final plat. And that might be, just for example, instead of granting them a condition of approval to take 120 days to record the plat instead of 60 days, if that's necessary to install street trees and sidewalks. That's just a thought right there. But Commissioners, I've done a ton of talking and am happy to answer questions, and we can go back and look at any slide or any item.
Buford, if you don't mind, let me go ahead. This is a public hearing, and let me open the public hearing first.
Okay.
And then I'll shut down the public hearing, and at that point, the commissioners, that may bring up some more questions in the commissioners' minds. And at that point, I'll turn it over to the commissioners and let them ask you any questions that they may have at that time, if that's all right.
That's great, Mr. Chairman. And what I've done is I've gone back to the very first slide, and so carry on, and I'm ready for questions when we get through.
Thank you, Buford. Excellent job on that. This is a public hearing. People, it's one nice thing about this Zoom type meeting is people can read everything that we put on there, where sometimes if you're sitting in the audience you can't quite see the television screen so well. This is a public hearing, so I'm opening the public hearing at this time. Would anybody like to speak to this item? Okay. All right, I think that's probably enough time. If somebody's trying to get in and can't, just buzz in at that point. I'm going to go ahead and close the public hearing at this time, and I will turn this meeting over to the commissioners. Commissioners, are there any questions, concerns, changes, anything you're uncomfortable with the change of this resolution? I've got just one item. You know, I don't want to lose my nickname as Mr. Sidewalk up here. Because I just believe that's one of the biggest safety issues of anything that we do. And it really does bother me, having subdivisions that date back to, I think, how old is Quail Creek, Kevin?
Man. 20?
It's at least 20, 25 years, maybe even 30, and it's still got sections of sidewalk that aren't built on Quail Creek. And then when you think about street trees being planted, 2007 to now, a live oak tree grows a heck of a lot in 13 years. But I have one question, and this may be on the sidewalks that on 19. A says sidewalks are not required to be installed in the right-of-way where lots front on and have access to existing streets or roads, and such streets or roads are under the jurisdiction of another governing authority, and that authority prohibited installation of the sidewalks in right-of-way. In such event, the commission may require the installation of sidewalks, easements along the margin of lots adjacent to the right-of-way. And I don't think this change is worth necessarily, coming back, but I wondered, what if we just said, if governing authority has prohibited the installation of sidewalks in the right-of-way, the commission will require installation of sidewalks and easements along the margin of the lots adjacent to the right-of-way. Ken, do you think that makes any change? I mean, I know it seems a little pedantic, but I was wondering if, it says another jurisdiction, which would be Baldwin County, but I guess I was just thinking that, it makes it sound kind of like it's the commission's pleasure to me, in those cases when you get out like 104, which is, one of the fastest growing areas and was absolutely rural 5 years ago. And 104 and 181, I think, is Art Dice's favorite intersection in Baldwin County, if I remember. But, areas out like that where maybe the county doesn't want it in the right-of-way, that, we are going to require them, and just let the folks know on the front end that just because the county may not necessarily allow a sidewalk in a right-of-way, that it's going to be part of your subdivision.
What you stated is the intent of the proposed language, Lee, but as I was looking it over again, some streamlining could be done to make it read a little better, but what you stated is the intent of the proposed language.
Okay.
Well, basically what we're saying is we don't have ultimate say over all of the rights of way within our planning jurisdiction. We've taken that into account, as we must from time to time, as we've looked at subdivisions out in the county. And I mean, the fact is we can't make people put sidewalks in someone else's right-of-way, and we're just taking note of that fact, but advising applicants that if that's your situation, the commission may require you to put sidewalks in an easement. And so it just takes into account the existing facts and law and the way we've dealt with it historically.
Okay, because I've just heard so often, the engineers get up here and they, make that a huge issue that the, county won't allow them, the county won't allow them. And you're like, well, just move it over a foot,
Exactly.
So, but you're pretty comfortable that way we're not going to have people come in begging and then have to send them back or make a big issue, that they're not going to have to redraw it and, give us a crying sob story that they're going back to the drawing board and redesigning everything and all that kind of stuff.
I'm not sure what you're asking, Lee.
Well, I think it behooves the developer to ask that question on the front end, so they're
Well,
not assuming
okay.
that they get it in the right of way.
There may be a transitional period, maybe after this, if this gets adopted, that people who hadn't been keeping up with it submit plans that they know the county won't allow it, so they just don't put any sidewalks. it'd be wise to go ahead and address it on the front end.
Well, I think answered my question that it does, and that, I just didn't want it to come in, different commissioners, whatever, who don't know the back story, and somebody says, oh, it just says y'all may, and the county won't require it, and people don't understand. I just, the more emphatic we are, the better. But if you're comfortable with it, I'm comfortable with it. And I think it's important to do it now. I mean, I don't want to put it off.
Okay.
And Mr. Chairman, if I can jump back in before
Yes,
we
sir.
get ready for a vote, and again, we'll answer as many questions as possible. So just to refresh your memory, we'd like to pull item 3 and item 5, and then request the Planning Commission to adopt the rest, if that pleases the chairman and
Now,
commissioners.
3 and 5, for slow people like me, you're talking about number 3, so the second page, lot.
The item on your screen right now, and I agree, that was a great suggestion by Hunter. We will beef up the wording a bit more, because he's correct. There may be an older PUD that hasn't been acted upon where we may require a community meeting. So let's pull this and we'll revise that wording a bit more.
Item 3 is right there, because we don't have those same exact numbers.
Wait. What is 3? You show, what I've got is item 19.
Hey, I was a little confused by that, Art. If you look on our page, the very second page, you've got a 3 and a 4.
Okay, if you look at
And
the
the-
actual resolution, they're numbered.
No, I don't have a 3 and a 4.
The
You
little
talking about
bitty,
number, parenthesis, item number 3?
Yes.
Yes.
No, I don't have any of that.
Yeah, okay, we don't have the parentheses, but look.
But I don't have those.
but Art, do you see where it's numbered? You got a 1, a 2, each page has 2 numbers on it.
Yeah, all right, so.
The
that's
number 4 on the
3.
bottom, that's how I've been kind of cross-referencing. That's
All
how
right,
I can
3,
keep up.
and then, 5 is submission requirement?
Yes.
Okay.
So that's
Yeah,
basically.
I had a, all right.
Yeah, we have a little 4 and a little 6 kind of numerical tab on ours. We don't have those item numbers, so that's kind of how I followed it. So
Yeah.
I'm up to
I'm
date
with
on
you.
it.
Okay.
So Article 4, Section B, and then Article 4, Section D1A, et cetera.
Lee,
Okay.
if you're looking at the actual resolution, it'll be number 3 and number 5. It
Yes.
should be in your packet.
Yes, I understand.
Okay.
I understand.
So this number 5 is number 5 in your resolution.
Got it. I've been following the red and blue.
Yeah. This number 3 is the number 3 in your resolution.
Perfect. I got it. Thank you for clarifying that, y'all.
Okay, I got it. Okay, in the resolution itself.
Yes.
In the resolution, it's 3
Lee,
and 5.
Lee, are you through with your comments?
Yes, sir.
I got a couple things here, and I think I'm having a hard time hearing on, obviously for the cloud cover where I am today, but I think it was Rebecca at the beginning under number 2. This is in the resolution now. In number 2, Article 2, definitions of subdivision regulations, and it has to do with a lot, parcel of land, the definition of a lot. I get real uncomfortable. There's several of them in here where it says, something like it's. In other words, a very general. For example, in this one, where a unit for transfer of ownership or for building development of both, which will generally front upon a public right of way. Blah 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 blah. I don't. The one thing I've always found is the more concise, the more direct you can be, instead of leaving anything open to the imagination, the less problems we're going to have for the planning commission and the county commission are going to have down the road. I mean, the planning commission and the city council are going to have down the road. And so Buford, where it says will generally front upon a public right of way, what does generally mean?
So
No.
and Ken, jump in,
Wait.
get ready.
Either it do or it don't.
Well, that's true, Art, and that's my language. What you say is true, but the commission has historically, certainly in the last year or two, approved subdivisions which included lots which were not on a public road, allowed some form of access easement, and we're now, because the commission has shown an inclination to do so at times, we are expressly allowing for deviation of that requirement in the regulations. There was always an exemption for rural and agricultural subdivisions that was in the regulations. So if we had a definition of lot which said it's on a public right-of-way, and then we went about approving subdivisions that had lots which were not on a public right-of-way, our own definition of lot and our actions would not be consistent with one another. So what I'm intending to convey here is, as is conveyed elsewhere in the regulations, generally we expect every lot will be on a public right-of-way, and indeed on a publicly paved street. But that's not always the case, and we're just recognizing that that is not all the case in the very definition of lot.
Okay, well, I've always had a problem with the requirement, whether it be, and you think about the city limits. Let's talk about the city limits as opposed to the police jurisdiction or the planning jurisdiction within subdivision authority within the rural area. But even within the city of Fairhope, there are a lot of places. You got properties that don't have that. There's no way they have access or frontage on a public right-of-way. They never have, and they probably never will. I've had a real problem with that verbiage because I think it is much too restrictive. We've got one tonight in our package that pretty well is identical to what we're talking about right here, and it's I know there were many times that we've had I know in the county where you could have an easement that could only serve up to a certain number of lots, but that was a bona fide easement, not a right-of-way, but an easement, served the purpose of providing access. And I don't think this takes that into consideration. Does it?
It sounds like to me that it does with the use of the word generally. I mean, I know I started it with that question, but I felt sort of satisfied by the answer that
I don't think generally or sometimes or maybe or anything like that gives us any protection. Or even the one thing that I've come to understand is if people absolutely know what the rules are, they don't have a problem with it. They know how to play the game if they know what the rules are. But when you start including terms like generally or maybe or sometimes or whatever, I don't even know what that means. So I just don't see where, it leaves us open to making a ruling one time in one way and another time in another way, which I think is going to get us legally in a bind.
Ideally we would like for all lots to front on a public right of way, but there are exceptions. So then I think.
Why do you want them all to front on a public right of way? Why?
Because then you don't have
that's my point. It's not going to happen. There are lots of properties.
Ideal. This to me expresses the ideal situation where public services like fire and whatnot are provided along a publicly maintained right of way, but it leaves the door open that there may be exceptions where that's not the case. And I don't know legally if there's a better way to express that. I was kind of confused by it too, but I wouldn't want to go in the direction of just giving up the idea that we would prefer lots to front on a public right of way.
Buford, Ken, you were.
That's still nebulous. If you prefer it, well, do you require it or do you not require it,
Well,
or do you prefer it, which is neither of the above?
Yes, I mean, some things are nebulous. I think if you know that not everybody can comply, it's still okay to express an intent.
Well, I just think when it's open to interpretation, that is where we have a tendency to get in a bind legally.
Yeah.
Well, if I may, no matter what we do with the definition of lot provision, they can go either way. Will present itself by virtue of the regulations themselves, as some revisions are being proposed, and it in fact has already presented itself because the commission has from time to time here in the last couple of years approved subdivisions with lots that didn't front on a public road. I mean, if we don't make this change and don't change the provision as it exists, the definition of lot will be a unit of land that fronts on a public road. And so this revision takes into account that, again, what the commission has shown a willingness to do on a limited basis historically, and by virtue of some of the revisions that will be discussed later, be expressly allowed in the regulations for lots not to front on a public road as long as there's an appropriate access easement. I mean, your points are well taken and really point up the, I don't know, tension's too strong of a word, but what's in play here. I mean, I'm not a planner, but I think it's common sense why planning commissions and folks that run the city want lots to be on a publicly paved and maintained road. That's so people who are buying those lots, the constituents, can get to them conveniently and efficiently, and services they need to have provided to them on an emergency basis or otherwise can be effectively and efficiently made.
Okay, so that they can have water and they can have fire protection. Would that be one of the things? Because let me ask you this.
So that an ambulance can get there if they need to, without having to go
through. If you've got a utility easement that allows the power and the telephone and whatever else, why does it not allow for the city to install water up that easement? I don't think it does. I think they can install it up there. And if they can, then they can put a fire hydrant there. But let me give you a good example. And I guess what I'm trying to tell y'all is, from experience in dealing with the county, we did get sued over some of these issues because they were not specific enough. And let me just ask you, Ken. I'll make it real simple and won't make it 1,000 feet. Let's just say 100 feet. What if you got a lot that sits out? Let's say we got one that sits on a public road, and there's a piece behind it, 2 pieces behind it, and the people wanted to subdivide it, but neither of those other lots front on a public road. Okay, well, all those lots don't front on a public road, and it's 100 feet to get back there. And you say, okay, well, we'll do, and now we as the planning commission make a decision that we're going to allow them to do that subdivision, because generally it's we generally would like to have it on a public road, but in this case we're going to allow it. Now, wait a minute, time out. On the other side of that, you've got the next one comes to us and it's 150 feet. Now it's 150 feet and we say, oh, no, you can't do that. That's not it. Well, there's no reason why. You understand? There's no specific reason why 150 feet didn't work, but 100 feet did. And there's no line of demarcation that gives you any real solid footing, is the way I see it.
So I wasn't disagreeing with you on that. I just don't know that this sentence is where we do that. I think if you start off and say something like this will generally front, if we back it off from front, because we realize we're not applying that consistently, and we say will generally front, then we're required to be as clear as possible about the conditions that allow it, either way.
Okay, great.
Could I speak to that for just one second?
So you allow one and then you don't allow the next one, and what do you have to, what footing do you have to stand on?
Hey, Art, let me speak to that for just 1 second. I totally agree with what you're saying in principle and in theory, Art. I just don't know if that's the place for it or this is the time for it. I think that, right now we're just talking about the definition of a lot. And I don't think there's any way without spending, 300 pages. I sell insurance for a living, and there's a reason that, insurance policies have gone from, 20 pages when I started to they're up to about 90 now because of all the lawsuits that have made stuff get defined more and more carefully. But I don't think without 100 pages there's any way to get a specific definition of everything a lot could or couldn't be in Fairhope. But I don't think this is the part of it. I think in general here we're trying to say this is what we kind of consider a lot. I think we need to have at some point in the future a special meeting, and I think that special meeting needs to be geared toward family subdivisions, because on the major subdivisions, everything's going to, front a street. And I think that, we're trying to talk on these minor subdivisions of little issues here and there to help families, divide their minor subdivisions. But, when we talk about, getting staff approval rather than P&Z approval, maybe that saves $500. But the real issue with family subdivisions, and I was talking to a friend of mine, Daryl Wasp, about this over the weekend. His 93-year-old dad has 10 acres with 8 family members living on it right now. And, no public street, no public anything. And the point is, allowing that land to be subdivided, the expense, and I know, and we discussed another case, with another friend, the same time, but the expense of subdividing that 10 acres for that family is not going to be to come up and get an application to the city. It's going to be, what subdivision regulations are we going to hold their feet to the fire? Are we going to require a publicly maintained road? Are we going to require sidewalks? Are we going to require water retention? And what are we going to require? And I think that, if we're going to really look at doing some type of a not named family subdivision, but if we're going to try to do something on minor subdivisions, that we allow exceptions of publicly, public streets and all that, that we probably need to look at what exceptions the staff suggests that we accept. I like to listen to you, Art, because, you dealt with the county. I've been on this board for 20 years, but we've never had a family subdivision in the 20 years that I've been on here. So I think, when we get kind of past some of this COVID stuff and can have an in-person meeting, I think it'd be really good to have a meeting on kind of minor subdivision / family subdivision and what kind of requirements. Like if you've already got 5 houses on a piece of property that, have been metered, maybe we allow that, but we say, because they've been living there for so long, but we say, hey, if you subdivide it again, then you've got to have all of these kind of issues, or you can't sell it for 5 years, or we come up with some stipends so that it's not, utilized for people that come in with the 50-acre parcel and do, divide that into 4 pieces and then divide those pieces into 4 pieces and so forth and so on, just to get around the system.
Chairman, this is like, Art, hold on just a second,
Art.
Art. Hold on. I think I can help you get to where planning staff is going with this solution. And at the end of this agenda, there's going to be another discussion about just one of those options that Lee's talking about. So this is just the definition of a lot and how we follow up with when it is applicable to allow another solution besides fronting a street or a public right-of-way. We can handle those in other sections. So we allow that clarification in other sections, but this just empowers those other options. So I think we're on the solution you're looking for, but we need a little bit time to get there. So, but this gives us the step we need to go. I think we've got right now, rural subdivision, for example, has some options, and it's exactly those things, and you'll see that in some of the examples as we get to the end of the agenda. What you're talking about with easements in those lots that are kind of landlocked, that's exactly what we're talking about and what this will provide us and empower us to do with those solutions.
Okay, I just, never been a fan of having a word in there where you may address it later on, but when you leave a word that is, very loose, there's an opportunity for a legal mind to grab that word and beat your brains out with it. So that's it. All right, on to the next thing. On number 4, under these tree protection fences, do y'all have rules on? And I know down here below it says something about 1 foot of width per inch of diameter of the tree, but in number 4 there are the rule needs to be fairly strict. 1 inch or 1 foot of width, diameter width of the fence away from the tree per inch of diameter of the tree. For example, a 20-inch tree is going to have 20 feet. With a 20-inch live oak, that doesn't even begin to get close. You gotta fall back on your drip line. That's where you're going to not destroy your good trees. Drip line. That's the outside most portion of the canopy of the tree.
And Art, you're on to
Commissioners,
something.
can I jump in?
What?
So, Commissioners, we have a standalone tree and landscape ordinance, and that is applicable within the police jurisdiction, and the authority having jurisdiction there is the city horticulturalist. So, I appreciate the comments. That belongs in that ordinance. And
Well, you've got it in this ordinance though, Buford. So either take it out of this one or deal with it.
I think we need to deal with it, Art, and I don't think we need to pull this. We'll just make note to come back with our next revisions and marry that up as well. That was the intent here, making sure sub-regs marry with the tree ordinance, and we'll continue to do that. So thanks for pointing that out, and we'll get that covered.
I agree with you. My point is that what you've got in here, I think it does need to be in here, Buford, and I agree with you. But I just don't think it's adequate. I don't think the diameter is for the number of trees, the types of trees we have, are appropriate.
Okay. So we have an additional future edit that we'll work on.
Okay.
All right, any other questions?
Right, that would be an edit to the landscape ordinance, right? Not just this.
I think that landscape ordinance is clear and does exactly what Art is describing. It talks about showing where the tree canopy is and matching the protection with that. I think we just got to match our sub-regs to the tree ordinance.
That's
And
it.
maybe establish a minimum, because I think it refers to the diameter of breast height.
Well, that's all we're considering today, is making certain the diameter of breast height, that both documents agree. But appreciate the comments, and like Hunter said, we'll come back to that to make certain the subdivision regulations do a better job of contemplating the tree ordinance.
All right, any other questions or concerns, commissioners? If not, I'll entertain a motion.
Come on, somebody step up.
we move to approve that with everything we just discussed?
Yeah, that's,
You pull item 3 and
Just
5.
say I make a
and-
motion, we approve the amendments to subdivision regulations minus items 3 and 5.
And to make it
That's
easy, commissioners, that's a request of staff.
Okay, I move that we approve minus items 3 and 5.
I've got a motion. Do I have a second?
this is John, I'll second it.
Any further discussion? And I just want to say, Rebecca, I appreciate your making that motion, because a lot of these things, you've brought up and kind of urged staff to work toward through time, and appreciate the input you've given.
Give Art a break.
All in favor, say aye.
Aye.
Any opposed, say nay.
Hey, Lee,
Yes, sir.
we're going to do voice votes. Ask for abstentions too, so we make sure we don't have an abstainer we don't know about.
Yes, sir. Are there any abstentions on this? All right, so the item was approved unanimously. Thank you, Ken. All right, next item on the agenda is SD 20.25, public hearing to consider the request of CFP Housing for plat of Mars Hill Subdivision, a 3-lot minor division. This is held over from our last meeting. Buford, is that you again?
That is me, commissioners. And commissioners, I'll try to make this one pretty quick. If you can indulge me just a second to get my slides working. Okay, commissioners, can you see my cover page and see Mars Hill Subdivision?
Yeah.
Yes.
Yep.
Okay, commissioners, so you saw this subdivision last time.
Wait a minute. Now I can't. Somehow, something happened. It jumped up high. I can only see Sonny Callahan Airport. Is that just me, or is that everybody?
I
I can see it.
says ST 2025 Marshall Subdivision on mine.
Okay, I'm just having problems. Y'all go ahead.
Okay, commissioners.
There you go. I got it now.
All right, it took just a moment to refresh. And commissioners, Mr. Dewberry isn't with us here tonight. He has retired. So when you see
What?
Steve, yes, sir.
What's he gonna do? What's he doing?
I will leave that up to Mr. Dewberry himself.
You mean he don't love us anymore?
He does not wish to participate. He does not wish to participate in this fund. But commissioners, when you see him, wish him well.
Right.
So when we saw him last time, that was the last time we saw him at a meeting. But commissioners, we've seen this case before. They have changed the plat. The location you see right there, this is unzoned Baldwin County, the aerial map, and then the various characteristics of the property. You see the lot size and all the backgrounds. The owner developer is Mr. Pilot, CFP Housing, as we saw last time. The major correction, the major revision that allowed this to become a recommendation for approval, commissioners, and you'll recall last time there was an issue with lot access. So what they've done is reconfigured lot 1, which I've shown in light red, and made that into a flag lot. So therefore we have adequate access and frontage on Greeno on Highway 98. The lot sizes and lot widths were already correct. So what that revision has allowed this to become a recommendation for approval. What I've got for you here, commissioners, and this is in your staff report, is I went through line by line and explained the previous application and the changes that have made now. They did away with the private right-of-way they were originally requesting. They created the flag lot, as you can see. Though the sidewalk waiver does remain, however, they stated they're willing to place a pedestrian access easement along the margin of the affected right-of-ways. That way sidewalks could be constructed at a future time. The other provisions are essentially as last time. We'll have condition of approval requiring an operations and maintenance agreement for the stormwater system that was built when this property was originally developed. And the engineers acknowledged all of that as fine and doable. So our staff recommendation is approval. The conditions of approval, as you see right there, acceptance of their request for partial waiver of the sidewalk requirement, as we stated previously, they're willing to have and reflect on their plat a sidewalk easement or a pedestrian easement. What I would clarify there, Commissioners, is that I didn't word it as well enough. You may want to, in your motion, make it clear that the Planning Commission is requiring that installation of a sidewalk easement is in place. This site is more than 1 road mile from anywhere where there's any existing sidewalks. So as you see in item B, we don't object to that request for a waiver. The other condition approval is prepare the stormwater operations and operations maintenance plan and agreement. And so that's all I have, Commissioners. If you have any questions for staff.
Okay. Yes. Go ahead, Rebecca.
Okay. I had a question, maybe more general question regarding flag lots. This seems like, a good solution for this lot, but, there are other cases where we try to avoid flag lots. In this case, a fire engine can go down that access, you can get in there, they can turn around, it's fine. I can imagine, residential fire lots where there's not access for a fire engine, or even smaller commercial. It would, sort of building on what we were just talking about, it would be good to clarify, or I'd like to have more clarification about when flag lots are acceptable and when they're not.
And Rebecca, let me make sure we're not, we had a discussion on flag lots 2 months ago that when that was a requirement on hydrants, that's not what we're dealing with now.
Yeah.
Well,
and I'm not concerned actually about this project as much as in general getting some clarification on flag lots, and that kind of goes back to our definition of a lot. We don't want a torturous lot that's just trying to touch a right of way.
So, Commissioners, if I can address that. And Rebecca, this won't answer every question, but it will answer this question and for this particular application, but is applicable to many applications. So this piece of property is located in unzoned Baldwin County. So the applicant must comply with both the Fairhope and the county subdivision regulations and comply with the most stringent of the two. The county subdivision regulations are very clear that if you have a flag lot, that the flag pole, if you will, that reaches out and touches the right of way must be at least 30 feet wide. Okay. So if you think of the flag itself and you think of the pole as the portion that reaches out and touches the right of way, their regulations require it to be 30 feet. We basically mirror that in our staff recommendations, so that in general addresses that concern about access and vehicle passage and things of that nature.
Okay, thank you. So maybe, that might be good for us to mirror in our own ordinance.
Good idea. Good idea. We'll certainly consider it.
All right. I'll go ahead at this time and open up the public hearing for SD 20.25 Mars Hill Subdivision. That's the piece of property out, connects on Greeno Road as well as County Road 32, minus just a little bit of a corner there. What was the name of the Baptist church was there? Faith Baptist, I believe, was there for a certain amount of time. Does anybody in the public have any questions, concerns, or wish to speak to this item?
Mr. Chairman, I did receive one phone call, but they were not in opposition.
Okay. All right. In that case, I'll go ahead and close the public hearing at this time and turn the meeting back to the commissioners.
Motion, Mr. Chairman. This is Art. Case SD 20.25 Mars Hill Subdivision. I move that we approve it subject to staff recommendations and that for certain that they include the pedestrian access easement on that property.
I've got a motion to approve subject to staff recs and also clarifying that we are definitely requiring the right-of-way for future sidewalks. Do I have a second?
This is Harry. I second.
Any further discussion? All in favor say aye.
Aye.
Any opposed say, I'm sorry? Any opposed say nay. All right, and any abstentions? All right, the motion passes unanimously. Next item on the agenda is SD 20.29, USA map subdivision.
And Mr. Chairman, if you can indulge us just a moment. So Carla is going to have to join us from her phone app. So I'm going to do the screen sharing. So if you can indulge us just a second here to get this going.
All right.
Thank you, Buford. Good evening, everyone.
Good evening, Carla.
Okay, commissioners, can you see the slides?
Yes, we can.
Nope.
Okay, so again, this is case SD 20.29 USA map subdivision. This is a 2-lot minor subdivision approval. As you can see on the screen, there's a zoning depiction of the image. This is a public hearing to consider the request of MAP Limited Partnership, an Alabama Limited Partnership owner and the applicant of a 2-lot minor subdivision. The property is located on the east side of County Road 3, just south of Rose Bishop Lane. As you can see, that's the aerial of the subject site. The property is approximately 16.75 acres, and the applicant desires to divide the property into 2 separate lots. The proposed Lot 1 is approximately 8 acres, and the proposed Lot 2 is approximately 8.75 acres. As you can see, there's a site plan depicted on the screen illustrating both lots. The subject property is in Fairhope's ETJ and is unzoned. Article 6, Section D of the City of Fairhope Subdivision Regulations requires the provision of sidewalks along all streets in the planning jurisdiction of Fairhope. The applicant is requesting a sidewalk waiver. However, the preliminary plat does depict a 10-foot wide sidewalk easement along U.S. Highway 181 and Highway 104. Article 6, Section G also requires the provision of fire hydrants to be installed along each street at a maximum interval of 450 feet or at the ends of the center of each block, or as otherwise required by the fire authority having jurisdiction. The applicant is also requesting a fire hydrant waiver along U.S. Highway 181 and 104 for the deferral of installation of the fire hydrants until the submission of a site plan, and the applicant has stated that a site plan is forthcoming. The proposed subdivision does not include the building of any infrastructure at this time. Water services will be provided by the City of Fairhope. Power is supplied by Riviera Utilities. Baldwin County Sewer Service will provide sewer, and the telephone service will be provided by AT&T. The applicant provided 2 separate statements regarding the request for sidewalk waivers and fire hydrant waivers. The applicant, again, is depicting a 10-foot sidewalk easement along U.S. Highway 181 and 104. The applicant also is requesting the deferral of installations of the fire hydrants until submission of the site plan, which has also been approved by the city's fire representative. There are 6 criteria for waiver requirements, and all of the requirements have been met. There are also 5 criteria for approval standards found in the subdivision regulations in Article 4B2, which were met or were not applicable. Staff recommends approval of case SD 20.29 USA map subdivision subject to the following of 2 separate conditions of approval. Condition 1 of approval is the sidewalk waiver deferring construction of sidewalk until the site plan is submitted. And condition 2 is a fire hydrant waiver deferring installation of sidewalks until a site plan is submitted.
Carla, I think, can you say that one more time? I think you said sidewalk instead of
Oh,
fire.
I said it twice. Yeah, it's sidewalk waiver, easement being allowed, the depiction of the 10-foot easement, and then the fire hydrant waiver deferring installation of sidewalks until a site plan is submitted.
Carla, I've got one question before I open the public hearing, and this may, I don't know if this is, should be geared toward you or Ken. I don't have a problem with the sidewalk waiver at this time because they're just doing a two-lot subdivision, and obviously site plans are gonna come back on this. But if we do a sidewalk waiver requiring easements now, when the site plan review comes, do we have the teeth to require sidewalks at the site plan review? Because I don't mind a sidewalk waiver now, but when USA comes in with the surgery center and everything I've heard that's coming this way, I think sidewalks would need to be required then, and I'd just as soon not put sidewalks and tear them all up. But would we have the teeth at that point to require sidewalks?
Chairman, this is Hunter. Let me jump in real quick because this is outside the city limits right now. If they happen to come within the city, they would be eligible for sidewalk site plan review. If not, that's not the case. We can't implement sidewalk or site plan review, so we wouldn't have that option. It may be that we make this give this waiver now, but attach it to construction.
Okay, I mean, could we do the sidewalk as a deferral just like we're doing the fire hydrant?
And that's where I think defer it to time of construction. Because we don't know to building permit, because we don't know if this will be an MOP. Maybe an MOP and then we get the review, but it may be 1 or 2 units and we don't trigger MOP,
So then we could do a deferral of sidewalks and fire hydrant at the same time.
Until time of construction, and then if they come up with an MOP in between, we can handle it then.
Okay.
With a better review, and they can be more flexible.
Mr. Chairman, can y'all hear me?
Yes, sir.
And so, yeah, I concur with Hunter on that, because you have the situation where, and it's kind of semantics here and no need to go into detail, but a formalized site plan review is a function of the zoning ordinance, and this is unzoned property. Now, the lowercase s site plan, that is going, a lowercase s site plan, as I call it, is a drawing. Now, what if you have the scenario where we don't have an MOP, or there's not a future re-subdivision that comes before the Planning Commission? So like Hunter said, doing it at the time, this is an example of when it's beneficial to make that at the time of construction, so that way whatever sidewalks are installed are coordinated with and work with the vertical construction.
Sure. Okay. Any other questions for staff before I open the public hearing? All right, in that case, I'll go ahead and open the public hearing at this time. This is a two-lot minor subdivision. It's on the south side of Highway 104, the east side of Highway 181 at Art Dice's favorite intersection in all of Baldwin County. Does anybody wish to speak to this item at this time?
Mr. Chair, I would like to. My name is Sam Irby. I'm an attorney in Fairhope, and it's my honor to represent the MAP Limited Partnership and the MAP family. They are submitting this two-lot subdivision for a very specific purpose. As many of you know, the MAP family is a very generous, giving family, and after the subdivision is approved, they expect to gift Lot 1 to USA for the purpose of allowing USA to build a medical facility there. And it's going to be very special to the city of Fairhope, what USA has planned. Now, if you have any questions about anything, we'll be happy to answer it, but I would like to turn it over to Casey Hill of Dewberry, the engineers who can answer any questions. Do you have any questions of me?
No, Sam. I'll go ahead and if you would like to turn it over, that will be fine.
I'll
Yes,
do
sir.
that. I'll let Casey Hill do the details.
No, I'm not going to close the public hearing because more people may want to speak. Yeah, go ahead, sir.
Casey? He's supposed to be on the line. Do you have any questions for us? I'll try to
I've got
answer.
one quick question, Sam. Is Lot 1 the north or the southmost lot?
Be the westmost lot. Be the
Got it.
westmost lot.
I see,
It's at the
I see.
intersection. Well, Lot 1 is at the intersection of 181 and 104.
Got it. I got my north, south, east, and west. Yes, of course. I say, so lot 1 is the one at the intersection, and that's the one that you're saying he would be transferring, then lot 2 is the other. Okay.
Yeah, he'll retain lot 2, and will gift lot 1.
All right.
And I've talked to the probably some of the USA people on this call. They've got some fabulous plans for this. It's going to be a remarkable benefit to if you know the benefits. We all love Thomas Hospital, but USA has got some benefits that health benefits they can provide to the community that are going to be very special.
All right. Thank you. Sam, I'll go ahead. I'm going to open the public hearing, and then I'm considering you're speaking on behalf of the presenter. And if Casey comes in, that'll be good if he wants to add anything. But I'll go ahead and open the public hearing, and then I'll close the public hearing, and then the commissioners may have questions for y'all directly. But does anyone from the public wish to speak that's not with Dewberry or Sam Irby's office? All right, in that case, I'll go ahead and close the public hearing. I'll turn the meeting over to the commissioners. Commissioner Sam is on the phone if you have any questions, and I don't know if Casey will be able to come in or not. But do you all have any questions, concerns? If not, I'll entertain a motion.
Well, Chairman, this is Hunter again. I just emailed Casey. Casey, if you're in a situation where you're not able to speak, I just sent you a phone number. If you want to call that, we'll make sure you heard if you've got any questions. And I'm kind of stalling a little bit to give you a couple minutes.
Well, this isn't I mean, obviously, with the mass of what they're doing, this is coming back to us under something in the future. Right. But commissioners, any questions? If not, I will entertain a motion.
Motion, Mr. Chairman. This is Art. Case SD 20.29 USA map subdivision. Move that we approve, subject to staff recommendations, with fire hydrants to be installed at the time of, I think it was in time of construction, and that there be a pedestrian easement for sidewalks assigned to this subdivision.
Would you be willing to say sidewalks built at construction as well?
Yeah, that's what I thought I said.
Okay.
Let's and I'm sorry to interrupt after that motion's made, but let's think something through real quick, because Emily just brought up a good point. If this is a USA project, they won't come to us for a building permit. So I'm not sure we have.
We said at time of construction.
At time of construction would be fine, and we'll have to work on that creatively to get a review in-house, because since they don't have a building permit, there won't be any plans to review, there won't be any standards to meet.
Well, their approval, though, is subject to them building sidewalks at the time of construction. Right?
You left out fire hydrants.
Sidewalks and fire hydrants.
To the standards of the subdivision regulations. If you can do that, I think we'll cover it.
I just think he says subject to, yes, okay.
Mr. Chairman.
Can I jump in here a second?
Yes, Ken.
That's a good point, Hunter. Since we won't have building permit procedure to ensure compliance, I propose that these conditions be documented on the plat itself.
Okay, that makes sense.
All right. Art, do you want to restate that?
Yep.
Okay.
No, I can't. I could just, I know Emily's doing a wonderful job there.
Art,
and I will just add to it that the sidewalks and the fire hydrant installations will be noted on the subdivision plat also. Okay. As part of my motion.
Okay. So
pause this and let us write that.
Sidewalks and fire hydrants shall be installed and constructed at the time of construction, and a note shall be added to the plat stating.
As such, yes.
We need to add that they meet all of our requirements.
So, per the subdivision.
Per subdivision requirements. Is that,
Mr. Chairman, Mr. Chairman, this is Sam Irby. Can I have a clarification of that, please?
And just
And
one
you know
second,
we're
let me
gonna-
get a second and do that under the further discussion. Rebecca, will you second that
Okay.
motion with your addition?
Yes.
Okay, under further discussion, Sam?
As we've said, the map's gonna gift lot 1, and lot 1 is gonna be developed. Lot 2 is not gonna be developed. It's just gonna be vacant land. And I'm questioning as to whether you're requiring fire hydrants and sidewalks on the undeveloped parcel.
No, the motion's going to state when the building is constructed. So if something's constructed on Lot 2 without a further subdivision, then yes, they would be required at that point. I think probably the fire hydrant at Lot 1 would probably cover Lot 1 and Lot 2, would be my assumption. So we're probably just talking about sidewalks along 104. And yes, any construction would trigger that or future subdivision.
I support, Art made a very excellent point a minute ago when I was listening to y'all. As a lawyer and Art's got a lot of experience with it, he knows this. We'd like for it to be very specific as to what you're requiring so we have no confusion. That's the only point I'd like to make.
Right, well, what we're saying is any construction on either Lot 1 or Lot 2 is going to trigger the sidewalk requirement being met and the fire hydrant being met. So in Lot 1,
On said lot.
right, of that lot. So if Lot 2 is, nothing's done to it, nothing's going to be required. And then I would assume Lot 2 will either at some point come to us with another subdivision or will come to us with, a building. I doubt somebody would want a single-family residence next door to a surgery center, but maybe they do, in which case they'd still have to build a sidewalk along 104 at that point, according to the motion.
Okay, that clarifies it for me. Thank you.
All right.
I can read you exactly what I have.
Okay.
A note shall be added to the plat requiring sidewalks and fire hydrants to be installed to the specification of the subdivision regulations at the time of building construction.
Well, that implies that
For
would be
each
both
building
lots.
construction on either lot.
For each-
I would just add to that for each lot independently.
For each lot independently.
There you go. There you go, Art. That's good.
Perfectly. All right. Any more further discussion? If not, all in favor say aye.
Wait a minute. Whoa. You didn't ever get a second.
Yes,
Rebecca seconded.
Oh, I'm
Well,
sorry.
Rebecca, do
Okay,
you
I'll
second
miss
to the
that.
changes? I'm sorry, I
I'm
guess I
sorry.
should clarify. We had a motion and a second. Rebecca, I'm assuming you and Art are both okay with the changes made during further discussion?
Yes.
Okay, in that case, all in favor say aye. Any opposed say nay. Are there any abstentions? All right, motion passes unanimously. Next item on the agenda is a public hearing to consider the request of Corinne Snyder for plat approval on Ferry Road Estate, a 2-lot minor subdivision on .89 acres located on Ferry Road between Keeney Drive and Ferry Circle. And I went out and ate at Big Daddy's for lunch today to make sure I could inspect that, so.
Thank you for your hard work.
Yes, I'm so sacrificial.
Commissioners,
Carla?
give us just a moment to share screens, and we'll be
Okay.
right with you.
Buford and I are tag teaming again. This is mine.
Okay, Commissioners, can you see our slides?
Yes, sir.
Yes.
All right, thank you, Carla. Take it away.
Okay, this is case SD 20.30 Ferry Road subdivision, a 2-lot minor subdivision approval. As you can see, there's the zoning image on your screen right now. This is a public hearing to consider the request of Courtney J. Snyder, owner and applicant of a 2-lot minor subdivision. The property is located on the east side of Ferry Road between Keeney Drive and Ferry Road Circle. The subject property is approximately 0.89 acres, and the applicant desires to divide the property into 2 separate lots. The proposed lot 1 is approximately 0.37 acres, and the proposed lot 2 is approximately 0.5 acres. As you can see on your screen, there's a site plan depicted. The subject property is in Fairhope's ETJ, and Fairhope Subdivision Regulations, Article 6, Section D require the provision of sidewalks along all streets in the planning jurisdiction of Fairhope. The applicant has also requested a sidewalk waiver. However, the preliminary plat does depict a 15-foot drainage, utility, and sidewalk easement. The proposed subdivision does not include the building of any infrastructure at this time. Water and gas services will be provided by the City of Fairhope. Power is supplied by Baldwin County EMC, and Baldwin County Sewer Service will provide sewer. Again, the applicant is requesting a sidewalk waiver and has stated in the request that they would add a 15-foot wide easement along Ferry Road for future sidewalk construction. The request is being asked due to the fact that there are not any sidewalks within miles in all directions of this property, stated by the applicant. There are 6 criteria for waiver requirements, and all of the requirements have been met and reviewed by staff. There are 5 criteria for approval standards found in the subdivision regulations in Article 4B2, which were all met or were not applicable to the site. The staff recommends approval of SD 20.30, conditional upon the approval of a sidewalk waiver.
Okay. What is the minimum width of a lot in that area?
That
was my question.
I believe that's, is that 100 feet?
100.
That's what I was wondering. Are these lots 100 feet?
They're 91, that are actually not 91.
Yeah, well, it looks like they're
What-
91 on one
wait,
side,
wait.
and 5 on the
What's
other.
What was the question?
I was just questioning if these lots met the width requirement.
What width requirement?
I thought you had to have 100 feet on a publicly maintained road.
You do?
Yeah, there's roughly 92 feet for each one, based on the plat.
I had the same question, and I didn't know if there was, how, on which edge, because we're 92 feet on the frontage, and it's wider on the river.
Well, it's
It
not
actually-
wider on the river, it's rectangular, it's just the river curves, so if you
It's
measure
cut at
it
an
into the
angle, good
river,
point.
you know, I've got a lot that's 380 feet wide, but I've got about 2,400 feet of river frontage.
Can you zoom in on that, that plan you were just on? Can you zoom in there? So we can,
Well, and I'll tell you what, we can, that'll be a question for Seth. If Seth is with us and he can hear us, what is the lot width at the setback line?
I will have to get that for you. But I do not believe it's 100 feet. I will have to look. Give me just a minute.
Looks to me like it's the same width. It's a rectangular lot. It's gonna be somewhere around 92 feet.
and probably less, it tapers, that southern lot tapers.
So commissioners, with given that this one might have to be tabled.
I think so too.
Yeah, we have to table this one if the lot width at the setback line, because I'm trying to pull up the copy of the plat also, and yeah, because we have to table this one so they can try to reconfigure it.
Should I we can table it ourselves because our next meeting is less than 30 days. Let me go ahead and open the public hearing so we'll get that done. No, we won't, I'm sorry.
I don't know if, well, I guess they could ask for a variance, but I don't know what the hardship would be.
Yeah, I don't see how you can reconfigure it if the total is less than 200.
That's right.
Well, and also commissioners, that wasn't advertised too.
It was what?
The
waiver would have to be advertised.
Waiver wasn't requested to be
yeah, the
advertised.
waiver was not advertised.
Well, but okay. I mean, they could ask for whatever they want, but if they wanted a waiver, you'd be hard pressed to explain what the hardship would be. It's self-imposed hardships are not acceptable.
Let me go ahead and open and close the public hearing since we've advertised it. And then at that point, I'll entertain a motion to approve it, to deny it, or to postpone it. I mean, because we don't have to get approval to put it off to the next meeting if we want to carry it over, since the next meeting's less than 30 days. So at this time, I'll go ahead and open the public hearing. Does anybody from the public wish to speak to this item?
Mr. Chairman, we did receive one email that is in your packet. It was in opposition.
Okay. All right. If nobody wishes, there is one email from Arlene Di Pietro, 16799 Ferry Road, mentioning flooding in that area. I know people park the cars up the hill from that area whenever the river floods. Anyway, I'll go ahead and close the public hearing at this time and turn the meeting over to the commissioners.
This is Art. I would make a motion on SD 20.30 Ferry Road subdivision that we table until the next meeting in order to give them an opportunity to deal with the needed 100-foot width of lots on a paved road, on a public paved road, public road.
I've got a motion to table. Do I have a second?
I'll second. This is Rebecca.
Okay. Any further discussion? All in favor to table, say aye.
Aye.
Any opposed, say nay. Any abstentions, excuse me. Any abstentions? All right, the motion to table passes unanimously. All right, next item on the agenda is the request of Joey and Janet Langley to do a 2-lot minor subdivision on approximately 3.8 acres on Dewberry Lane at 9781 Dewberry Lane. And I assume this has nothing to do with Dewberry engineers.
I don't think so.
All right.
So this is Dewberry Estate Subdivision SD 20.31. This is again a public hearing, the request of Joey and Janet Langley for plat approval, 2-lot minor subdivision. The property is approximately 2.8 acres and is located on the north side of Dewberry Lane at 9781 Dewberry Lane. Oh, wow. Did the aerial load for anyone?
No.
I've got it in my packet that
I've got it in my packet.
Okay, great. I'll keep going. And the site plan did not load either. I'll go back. The subject property is in Fairhope's ETJ and therefore must follow our subdivision regulations. It is a minor subdivision and has been reviewed accordingly. It does not require, or they're not proposing any building of any infrastructure or improvements at this time. Gas and water services are provided by the City of Fairhope. Sewer is not available. Power will be provided by Riviera, and AT&T services will be provided as well. The preliminary plat, which I hope it loads in a moment, illustrates a 2-lot subdivision. There's an existing dwelling on Lot 1 and an existing 15 by 20 shed on the proposed Lot 2. There are utilities easements on the plat as well. The proposed lot, they do not front a publicly maintained road, but rather they have a 30-foot ingress and egress easement. The applicant has submitted waiver requests for frontage on a public street, and they have also submitted waiver requests for sidewalk and fire hydrant. Staff did receive an email from the City of Fairhope's fire inspector stating that he was not in favor of the waiver of a fire hydrant. He noted his reasoning for disapproval were that the location of the nearest hydrant, the road access, width, and condition, and then the hydrant that is across a major roadway. The 3 waiver requests, again, are going to be for the frontage on a paved, publicly maintained street, the sidewalk waiver, and the fire hydrant. Currently, there are no sidewalks in the nearby vicinity. Also, the lot is currently configured without a frontage on a publicly or paved maintained road. The only disapproval that we had, of course, is for the fire hydrant, and that is on the basis of the fire inspector's position of disapproval. Therefore, the staff is recommending tabling of SG 20.31 with the applicant's consent to allow the applicant to submit plans and profiles of the fire hydrant as a requirement of Article 6, Section G, and the resubmission of the application to reflect a major subdivision containing a preliminary plat approval request in lieu of concurrent preliminary and final plat approval. And I also have additional conditions as well, if you give me 1 minute, if it is the pleasure of the commission to approve.
Okay.
Hold on 1 second. Okay, can everyone see the screen?
Yes.
Okay, this is, can we see the plat now?
Yes.
Okay, so this is the plat. And that was our aerial view. And then if I click through.
So Mayor, while you're right there, how far is the nearest fire hydrant?
Over 1,000 feet.
Right, it's over 1,000 feet according to the fire official. And it is
Okay.
across the.
It's across Highway 181.
Yes, exactly.
Yes.
I've never seen where, just because it was on a major highway across the other side of the major highway, that was a problem. They just normally stop traffic if they've got to run a hose. But if it's 1,000 feet, that's. But what are they doing for fire protection right now? Nothing on the house that's already there?
We are not aware that that would be. I think Mr. Hunter Smith and the applicant is on the line. They may have more information in that regard. But I do want to, while I have it up, just mentioned, if it is the pleasure of the commission to approve, staff recommends the following conditions, and that would just be the acceptance of the 3 waivers. That is the waiver of the fire hydrant, the sidewalk, and the frontage on the public maintained road.
Mm.
Well, I'm here to answer questions. This is Hunter Smith. I'm here to answer questions with the applicant if you have any.
Okay.
I can wait to talk, or I can talk now. However you
No, thank you, Hunter. You're with Smith, Clark and Associates?
Yes, sir.
All right, go ahead. I'll let you speak now, and then I'll open the public hearing as soon as you're done.
Okay. So this is a in large part of family property. Has been that way for many years. I pulled a rough measurement on the fire hydrant. I got 950 feet from the site. And that may be give or take a few feet, but I feel like it would be less than 1,000 feet, but I would have to take some pretty certain, better measurements than what we already have. The purpose of this subdivision is to allow the family member, the son of the people living on what will be lot 1, to build a house on lot 2.
Okay, is anything else to add?
Well, I spoke to the fire inspector today, and right now we have before you, I guess we have 3 options. One is to table and work something out with the fire inspector, which is not what my client would like.
I can't speak for any other commissioners, but I'm gonna either vote to table or deny based on what I've heard from the fire inspector. So those are what my 2 vote thoughts are. I mean, it's hard for me to vote for something that doesn't meet the subdivision regulations, and the fireman tells me, that he's not for it. I'm not going to vote for it.
This is.
It begs the question though. When you get a subdivision that is of multiple lots, however many that is, as opposed to a situation where you've got a property that is not located anywhere near a fire hydrant. People have been living there forever. You got basically one lot. Well, now you're going to have two lots. Okay, so you got two lots. But the thought that I don't know. I have a problem dumping that kind of financial responsibility on somebody that's been living there for an extended period of time. I don't know what the answer is, though.
Well, we're not
maybe come
providing
up in the
something.
family things we're going to talk about.
Yeah, Art, that's my point of what we need to discuss. We talked about family subdivisions tremendously, and the question is, what are we willing to give up to allow these family subdivisions? Are we willing to give up fire protection? Are we willing to give up 100 foot on a paved road frontage? It's not so much, do they have to apply and come in front of us or not, but it's, you're the one that talks about if it doesn't meet the regs, we can't approve it. We got to do the same for everybody that we do for one. And, and I agree with you. I'm not talking negative to you, Art. I 1,000% agree with you with that. So, if we're ever going to address this family, subdivision, the point isn't, how people get their approvals. It's what are we willing to give up in a case when it's going to cost somebody, $30,000 to run a fire hydrant to a lot worth $25,000, or
That's right.
a $120,000 road to get to a lot worth $40,000. And if we're not willing to waive that stuff, then we might as well just vote to deny these and not put them off.
Well, though, Lee, and you're right. You're exactly right. You can't do for one, you're not willing to do for everybody, and don't start a precedent. So it begs the question, and I think we've talked about this a number of times. If you don't like the rules the way they are, or the regulations the way they are, then change them. And so maybe this is another one of those. The financial burden, and you think about people that are living in the ETJ of Fairhope, or Foley, or Bay Minette, or anywhere for that matter, that are in a rural area. They've never had fire protection. We had a situation in the county where it got to a point, there was a requirement they had to hook up to the sewer. Well, good Lord, could you imagine the expense associated with it, and provide water that was that would handle fire hydrants. Well, that was, it wasn't a one decision fits all, and this is certainly one of those again. So I don't know what the answer is, but maybe it is in the family subdivision.
Well, we can say it just like, in this one, there's no house there, so it's just basically, instead of buying a lot, it's like, I got a little extra acreage here, build a house here, just like the last one. Hey, this lot's wide enough, we get two houses in, that's a little more money for us. It's just a financial thing. It's not a, the question is what's best for, for us doing our job. Is it better to allow more houses without fire protection, to help somebody out financially, or should we hold the requirement? I don't know that.
Mr. Chairman, may I interject very quickly?
Yes, sir.
So, Mr. Chairman, if you look at the subdivision regulations, Article 6, Section G, fire hydrant shall be installed along each street at a maximum of 450 feet, etc., or as otherwise required by the fire authority having jurisdiction. And so, in this case right here, if it's the pleasure of the commission to table it, it'll allow the applicant to reach out to the fire inspector and or the building official and research this and determine, is there an alternative that will satisfy that authority having jurisdiction? And then come back to the planning commission with that information if they're able to come up with an alternative. Don't want to get into the alternatives right now, but there are a couple. And if you table it, that at least allows them to research that and determine, is there a way to come into conformance that the fire official will be satisfied with for this particular case.
Chairman, let me add on to what Buford just said, and Art,
to get back to that discussion, I know what our subdivisions say and what that relates to is International Fire Code, which the city's adopted. And regardless of if we require that at lot or when the building is done, that has to be done per the International Building Code. And as Buford just said, there are some allowances for that, alternatives, and we can allow that to happen by tabling and see if there's anything they can come up with. But just for instance, we've had letters from Barnwell Fire Department. I don't know exactly if they've adopted the International Fire Code, but they have said where there's new structures with where there's not a hydrant within 500 feet, please require that. So, I think we need to be cautious on when we give waivers and on those. And the fire code requirements are about structures, new structures, not lots. So that's just something to consider, and you'll see that pop up again in a little while.
But Hunter, it also, and I'm trying not to be one that talks out of two sides of my face, but certainly there's got to be an element of common sense involved in a lot of the decisions that we make, and that's what makes it so hard to make regulations that are fairly detailed and firm, and here's the way it is. If you don't like it, change it. Okay, fine. But maybe when we change them, then we've got to include common sense to things that are actually occurring now, as opposed to when subdivision regulations were originally put together for the city of Fairhope, or the city of anybody, or the county for that matter.
I agree. There needs to be some common sense.
But I tell you this, we require a lot of things out of subdivisions, but then we allow these 2-lot subdivisions to come in, no sidewalks, no water retention, no anything, just because. And the point is, I question, in these areas, you look out there at that last one, allowing 2 postage stamp lots right there on the bay. I mean, eventually you're changing the character of the bay. I meant the character of the river. You're changing the character of the country. When you're out there and you've got, a 3-acre lot, now you're, popping off a almost 1-acre lot, you're adding density out there, you're adding
but guess what,
where there aren't parks. But I don't just totally disagree with what you're saying, but I just think that, we need to look at the, at the family subdivisions and decide in these areas, what are we willing to give up? And I don't see how in the world I could ever vote for something that our fire official says not to.
And that's my point. I think you're right, Art. There is some common sense. There is some alternative means, but I personally, I think that should be coming from the fire experts and not planning commission deciding when those, we also look at comments for every subdivision we have from utilities, and we don't portray ourselves as wastewater or sewer experts either. I don't think we should start doing that for
well, and you know what, Hunter and Lee, it begs the question for the fire authority. I mean, you can't tell me that in their dealing with the equipment that they have today and the changes that have been made over extended periods of time, you can't tell me that they don't have alternatives to having to a one-lot owner having to put or absorb a $30,000 fire hydrant installation in order to build a house on a lot that isn't close enough to a fire. There probably is, and maybe that's what we should do.
That's why we're asking to table it, Art, to let them get a chance to speak with that.
And Lee, the other thing I was going to tell you about that 100-foot lots out there on the river. Mm-hmm. The problem those people have got, and I really at this juncture I don't feel sorry for any of them anymore. But in unzoned areas of this county where zoning has been available to them for many, many, many years, if they choose not to have zoning, which that is a prime example. It's in the ETJ out on the river. We don't have any control over it. If it was zoned R1A in the county, then it'd be it'd be a 40,000 square foot lot.
Hey, Art, if you keep getting on your soapbox, I'm going to start talking about sidewalks again.
Yeah.
Yeah,
Hey,
but
no, you
understand
make
what
a
I'm
good
saying.
point.
There are options for those people if they would, that they can deal with their own future. I read the email from the woman or whoever it was that wrote it about, this is not the way all these other lots are. Well, it's not, but there's no rule or regulation that prevents those people from doing what they wanted to do if they would have had 100 feet.
Right, agreed. And let me say one thing about, fire hydrants, and I'm just saying this from my little bit of experience as an insurance agent. The fire hydrants aren't really to protect the house that catches on fire. They're really to protect the houses surrounding it, because the God's honest truth is if your house catches on fire and is pretty heavily inflamed, you're best to tell the fire department not to put anything out, let it burn all the way, because it'll save you $20,000, $30,000 to haul all the debris off at the end of the fire. Once the hose hits it and everything's ruined anyway, all the water's doing is just keeping it from spreading to other houses. But if it burned all the way, it's just that many dump truck loads less of debris to haul off, and it'll save you $20,000, $30,000. But the most important thing with the fire hydrants is if one house is fully engaged, keeping it from spreading to other houses. So that's something that, not that we want to go against any international building code, but it's just, something to think of when you're out in the country and you've got one house that's on 5 acres and then somebody wants to build a house right next door. You're protecting one from the other. All right, do I have let me go ahead and open the public hearing.
This is John. I'd like to make a comment. I've been out to look at this, and I just want to make the comment that they've got that 30-foot easement. That looks good on paper, but in practicality, there's certain parts of that I think a fire truck would have a hard time getting down, even with the fire, if they had a fire hydrant. It's just, it's not that wide. It's not 30 feet wide, cleared anyway.
Well, the road is not 30 feet. And that's normally what you see. The easement is 30 feet, but all of that certainly could be remedied by a hurricane bulldozer.
You're right, and that's what I just want to make that comment, because the fire chief did make that comment that the road is not in good condition, and you got a 40,000 pound pumper truck trying to get through there. They're going to have a difficult time.
Who is that said that?
John.
Oh, thank you, John. I appreciate it. I didn't recognize your voice right off. Art and I are doing all the talking and Rebecca today, so I appreciate your comments on that. I think that's a good point.
You're right, John. That is a good point. It's good on paper, and it is on paper, but it's certainly it can be rectified in terms of access, but that's something they'll have to deal with.
All right, but that is something good for Smith, Clark and Associates to think about, is that, there are some concerns that commissioners have besides just purely that one exemption of the fire hydrant. I'm going to go ahead right now and open the public hearing. Does anybody from the public wish to speak to this item?
This is Hunter Smith. Can I give a little bit of background on this before we go to public hearing? Because my applicant wants to speak before the public hearing.
Absolutely, go ahead.
Okay. Just to let everybody know, I'm glad Art brought up the family division stuff and how that's impacting all these properties in these parts of the county. This division has already been approved through the county. They've already submitted to me an approval for a family division, which is required here because we're outside of the city limits, but inside Fairhope ET. And I spoke with the fire inspector this afternoon, and he has some ideas. What we would like to see happen here is rather than a table, a conditional approval with the condition that we come to terms with the fire inspector, and he is happy, and Fairhope's happy, and my client's happy, and they can move forward with constructing the home.
All right. Let me go ahead and open the public hearing, and the commissioners all heard you say that. I think, John's got some concerns other than that, and I think, it'd be nice for staff to relate those as well. This doesn't have to be re-advertised or anything, so I don't think you'd really be, we wouldn't be killing a lot of your time coming back at the next meeting, which is less than 30 days. But I'm going to go ahead, I'm going to open the public hearing at this time. Emily,
I have not received any comments for this one.
no comments on this? Anybody from the public wish to speak? If not, I'll go ahead and turn the meeting.
Is this the public hearing portion of the meeting?
Oh, yes, it is.
Okay, Ms. Langley wants to speak.
Okay, go ahead. Yes, ma'am.
Hi, I'm Janet Langley, and I am living in the lot 1 with my husband and my 91-year-old dad, who originally bought all the property. 2 of my brothers have lots in that entire area. 2 of my brothers have homes and live there. And an aunt and uncle have also built a home in that area. So we are your picture of a family plot here. And we are requesting this so that our son and his family can build a house next door. We understand the fire hydrant issues and hope that you will go ahead and allow us a conditional approval so that we can work with the fire inspector to get his approval to a plan to do something that will not only help my son, but also help the other 4 houses that are out there. We understand the road situation. We've worked heavily. A few years ago, we had the road, we spent about $7,000 and had the road crushed asphalt done on the road. Highway 27 Dirt's been working with us. We know we've got some issues right now, but we've had so much water and a lot of construction and things going on that we have not addressed it as of yet. And we were kind of waiting to see about the construction, whether to go ahead with the road repairs right now or wait until some of the big heavy trucks had to come through the area. So we really hope, I'm here with my 91-year-old dad, my husband, and my son, and we hope that you will give us some conditional approval on this. We appreciate you listening.
All right, thank you, Ms. Langley. Does anybody else from the public wish to speak to this item? All right, if not, I'll go ahead and close the public hearing at this time. Commissioners, I'll turn this over to you.
This is John. Let me ask a question. If we give conditional approval that chief has to work something out with the fire chief, what happens if they don't work something out? The fire chief is just not happy with anything that can be done.
We don't sign the plat. It never gets recorded.
We don't issue a building permit.
And
Okay.
I mean, we can withhold signing and a permit.
Mr. Chairman, if I can interject, that's certainly appreciate the request, but my concern is that this may be something where we need to have a note on the plat that requires a certain thing. We don't know what that certain thing is right now.
I agree with Buford 100%. And, in this case, today is the 6th. I think the next meeting's on the 4th. I don't know how, backed up the fire commissioner is, or if he'd be able to, do something for them tomorrow. But we're not even talking about a full 30 days.
Well, I think it's imperative, this is Art, I think it's imperative that we know what, before, my feel about it is we know what the fire marshal or the fire inspector, whoever it is, what they've got to offer before we just sort of jump into a pot not knowing what's in there.
I agree.
I'd be inclined to table it till the next meeting.
You want to make that into a motion?
Yeah, case SD 20.31 Dewberry Estates, I move that we table, is it 30 days or the next meeting?
Next meeting is
next
less than 30
meeting.
days.
This is Harry, I second that.
I've got a motion and a second to table. Is there any further discussion? All in favor to table, say aye.
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 Any opposed, say nay. Any abstentions? All right, the motion to table passes unanimously. All right, next item on the agenda, old/new business, discussion to consider the request of the City of Fairhope Planning and Zoning Resolution 2020-01 for proposed amendments to Article 9, Section E, Procedure of Exceptions for One-Time Splits, Fire Hydrants, and Subdivision Regulations. Will that be you, Hunter, or Buford?
That's going to be me. Buford's going to help me. And just, we kind of, okay, we kind of pulled a little bait and switch on you. Not really, but we wanted to rethink, instead of giving you technical language, how we kind of incrementally go about solving some of these family subdivision requirements. And one of those, we can't fix it all at once, but we got to start knocking some dents into the issue. And one of those easy routes is when there are multiple buildings on one piece of property. And we've seen those quite a few times. And I'm pulling something up. You know, the pros for that, and not to, we can't call it a family subdivision. And we might have to come up with a few solutions to get to our ultimate goal. But for this one, I'm just going to show you kind of what the solution is instead of giving you the language. And then if it's something that we have a good feeling that the commission would like to pursue, we can come back with the language to get there and amend or adopt. So there's the pros of this. It's quicker and easier for applicants. That's one of the things we're trying to do. There's predetermined methods that can give relief for providing new sidewalks and new hydrants. There's separate options to address road frontage. So this is the same things we were talking about earlier. When the easement is included, where it's appropriate. And then there's also, there may be, and this is one of those things that we've got to vet through Ken, and we can have discussions on. I'm not sure there's anything we can do administratively to create new lots, but it can certainly speed up the process and maybe done administratively. The cons to this solution, it doesn't solve all of those family subdivisions, and you can see that in quotations because I know that's come up a few times in the county, and we as a municipality are not empowered to do a family subdivision. So
why?
That's not, state law does not give a municipality the ability to do that. That is only a power given to a county level.
Why? Any idea why? I'm just curious. Why is that? Because that was part of what I was going to talk to you about. But why do municipalities not have the authority to have family subdivision, but counties do?
That's a good question. Our fact is, the legislature, by express provision, has authorized counties, or actually what it has done is exempted family subdivisions as defined by statute from county subdivision regulation. The legislature did not see fit to grant a similar exemption from municipal subdivision regulation, and therefore you would, applying the general rules of statutory construction, conclude that it meant not to, or that exemption not to exist as to municipal subdivision regulation. You know, legislative history in Alabama is scant. I would surmise that if there's any basis to that, it is that subdivision regulation largely, not entirely, but largely is a creation of or spawns from municipalities where larger numbers of people have congregated, and therefore the need for more regulation for public safety exists simply because of the larger numbers of people in close proximity to one another, a larger number of buildings in close proximity to one another. As you move out into the rural areas and into the, quote, county, the need for that kind of regulation to advance safety diminishes. I surmise that is again, if there's any real basis for it, that would be the basis for family subdivisions being exempt by statute from county regulation, and the legislature having not provided a similar exemption from municipal regulation.
Well, you would think maybe that would be appropriate for Birmingham, Montgomery, and Mobile, but my goodness, Fairhope and Loxley and Somerdale and the like, and even Foley, really? Most of their areas within their police jurisdictions are rural. I mean, it's that way throughout the state. Anyway, it is what it is.
And as you'll see, as we get to the one-time split provisions, and we take into account that, while Fairhope may be growing in one of the fastest growing counties, there are parts of it that are still very rural, and we try to take that into account to some extent.
Okay. I'm going to jump back in, and just to clarify, Ken, I know you and Buford have worked on some great language for one-time splits. That will follow up this presentation at another meeting. This solution is a little different, and we hope to tie that into a one-time split if this seems like a good solution. We're not going to get into the semantics of the language, just in general, if there's a palette for this solution. So with that, it's more visual based. So we'll jump into the next example. So I've tried to find property that's outside of our planning jurisdiction around the county. As you can see, I'm kind of hiding road names, but this is within Baldwin County. And what you see here is a standalone single-family residence, and then another looks like a manufactured home to the side, to the east of that. Under this condition, they have the dimensional requirements and the road frontage. So all we're looking at here is sidewalk, and this makes it where we have a comfort level. There's a threshold, sidewalks are not needed. And then per the fire code, they do not need a hydrant because they're not introducing any new structures. So very important to this concept is there is no new structures created. It's just separating. If this was in the city, you could think of this as making a non-conformity where there's two houses on a lot into a conforming pieces of property. Buford, if you'll go on to the next one, we can look at example 2. This gets into Rebecca's question. So this is new lots before the subdivision, after the subdivision. And these are examples that we've drawn, not applications. But under these conditions, the only thing we look at is hydrants and sidewalks. So if we have a threshold where sidewalks aren't needed and fire code doesn't require a hydrant, this is okay. Now we get into the easement. Buford, if you'll hit the next one. So Art, this is your example. Landlocked family property that, frankly, there's no paved road even where the right-of-way is on this one. But let's say somebody wants to split those two lots. If we had a standard under this where this is an appropriate time to use an easement in lieu of fronting a publicly paved right-of-way, this would be that solution. And again, same things, existing buildings, so no hydrant required, and sidewalks are not in the area, that would be it. So example, next one, Buford. Now it gets a little, mobile structures kind of gets a little, I'm not sure what we do on this, but let's take that little blue square if you can see that. This is 8 lots. Each lot has 3 mobile homes on it. So if someone wanted to come in and split that, Buford, you can hit the next one. They could create, that's 300 feet road frontage, so they could create 3 lots that match the subdivisions. I'm not sure if mobile structures need a separate section that can kind of be put in to create a split and then moved off quickly. But it's something to consider. Buford, the next one, if you look at the since we're in that vicinity, this could not be subdivided because it's substandard dimensional requirements. They don't have 100-foot lots. All of those things will be check boxes that would have to be met before we even entertain this. So, on the next one.
Wait, stop, Hunter. Go right there on the trailer park with all the trailers in it.
Mm-hmm.
How does somebody do a trailer park then?
Art, I went
according to our, because I mean, realistically, not everybody can afford a house.
I get it. Trailer park is one thing. That's an MOP.
We had to deal with that also in the county, and it was tough. But
you're talking about apples and oranges. We're talking about a family subdivision.
We're talking about splitting lots. That's all on one lot.
If you want to do a trailer park, you got to get R5.
That is one lot.
MOP.
You got to get R5 zoning coming on the MOP to do your trailer park.
Yep. All we're talking about here is splitting and getting an option for a family subdivision.
I got it. I'm sorry. I was off on another tangent.
I got you.
Yeah.
We'll keep you
Art,
there.
look at the slide I just put back up, and so you'll see what Hunter was talking about. I put it back up here for y'all to look at it again.
So those are 8 lots on that cul-de-sac road, and each of those lots are 300 foot wide. They have 3 mobile homes on those. That could be split into 3 lots. Now, the one next to it, to the west, is all on one piece of property. Under this solution, this wouldn't be able to be split into multiple lots. So my point there is, if under this solution, we're not all of a sudden allowing 20-foot lots. They still have to meet the dimensional standards. And then if you want to look at anything for mobile homes or RVs or anything like that, we can further limit. But as you said, that would be a MOP in the county and a zoning change in the city. Talk about some of the concerns and kind of feedback I'd like to get before we start writing if this is step 1 in our solution to the family subdivision problems. Where would this be applicable? Within the corporate limits or planning jurisdiction or both? Any thoughts? Well, first, let me just, in general, is there any major heartburns with us? Because what I don't want to do is spend hour upon hour of drafting some technical language, and then we kind of stare at it for 6 months. We need to start getting some solutions. So in general, is this solution palatable to the commission? And we'll certainly bring some draft language to you and let you get another whack at it.
I see both sides, and Art's probably got a lot better view of this being on the county than I do. But, I see, we hear so many people talk about, does every single piece of property in Fairhope need to be subdivided? Does every piece of property need to be allowed to be subdivided? Do we need to make exceptions for everybody? I mean, we talk about real estate prices here like they're insane, but you look around the country, they're really not that high. It's not with 2.875% interest rates. You're not talking about, dirt's as cheap as it's ever been, for people to build houses now. I like a lot of the ideas. I hate when I see these people come in here, especially a lot of them that I've known that have had land and, Pawpaw let, little Joey build a house on the back 40, and then, little Joey wants to get that land subdivided, and then all of a sudden, what about a fire plug, down that half-mile dirt road? What about a right-of-way? What about public, and I get that. And on those, you really want to make exceptions for them, but on the other hand, when somebody's got 16 acres and they come in and do in quotes, put a trailer on the property and do a family subdivision, wink, wink, and then move the trailer over to the other piece of property and do a family subdivision, and another piece of property, don't tell me they won't do it. That's my concern when we, start allowing, these items. I think if we're going to do a family subdivision, to me, the biggest things would be, is the structure there already? How long has it been there? you know, how long until you know, if it's ever subdivided again, then it triggers all subdivision regs. You know, I think you'd have to put a lot of stipends in there that, you know, the property is actually going to a, you know, grandchild, parent, you know, son, daughter, what have you. That they've had to have been on it a certain amount of time, or that if it is subdivided and you allow them to build on it, like this, what you're talking about wouldn't help the Langleys tonight.
Right.
Because there's nothing on it. But if you're gonna allow an exception, you know, for a case like the Langleys, where they've got the little town, which is wonderful for everybody in the family to be close and be able to do that, then in this case, you know, if that property's re-subdivided, or, you know, how long until, you know, then it hits all subdivision regs. Or in a case like the Langleys, I mean, you know, people would come in and do that and then flip the house, and, you know, I mean, not saying that they would, but I'm saying it allows that. I don't think there's any way to keep, you know, require people to maintain ownership for a certain amount of time. After that, say the property couldn't be sold for 5 years. If you do that, Kim would probably tell us to get on thin ice.
Right. I don't think we can tie it to that, but
You know, I'm either for not doing anything on this, or if we do something on it, saying that, you know, you would have limits on, you know, just basically how long people have had the land, how long it's been in the family, and then, you know, a requirement that if it's ever re-subdivided, that any time, just once, you know, that at that point, you know, all subdivision regs have to be.
and that's where, so I'll kind of jump down to that third bullet point, and limits on, you know, the concerns that we had as staff and what we need to address with the proposed language. Limits on future development of sites, and is, when are the improvements triggered? And from the verbiage here, and I'm not sure how we get there, where Ken would be comfortable, I'll put it that way, where we have some legal backbone to that we're doing the right thing. This would not be a waiver, an exception, or exemption. Instead, this will be a deferment of those requirements, as long as the property remains what you're speaking about. It's historically single family, it's those homes. And I think that's a great idea. That could be a solution for something we've been struggling with. How's the threshold? And maybe the house has to be been there for a certain period of time to be meet this requirement. Because most of the things in the last 10, 20 years have went through a building permit, and, you know, they would have to have their own lot anyway. So I think that's a good solution that we can look at. But before I kind of go through the rest of this list, was any other thoughts?
I would love for you to just send us email to each of us these concerns, and
okay,
to let us think about these. And then I don't know, maybe at some juncture, if we're going to deal with it, maybe it needs to be another one of those outside planning commission work sessions.
Okay.
I think so, and I think maybe some of the engineers, and I tell you, you know, there is no free lunch. I mean, every ordinance that we've ever done has always had some kind of a downside to it, you know. I mean, there's nothing that's perfect.
Well, and I don't want this to come as critical to the commission. That's the last thing I want. The help that y'all give us is invaluable. But there's been solutions. You know, we kind of are kicking this can down the road, and I know y'all probably hear some of the concerns. We hear it every day. It takes up a good part of our life from all the folks that want these family subdivisions, and we haven't got any solutions yet, and I think it's been at least heavy on the agenda for a year or so now. And this one I would like to, instead of getting in the big picture, let's take small bites out of it. If we can come to a conclusion on this one, then we can follow up with, okay, now what do we do when somebody wants just do a family split that doesn't have a structure on it? You know, is there acreage minimums, or is there lot size minimums? or-
I think what Art said, send an email out, get our input, and if not much input comes in, then it's obvious that people don't care that much about it, and aren't that interested in doing anything.
Hunter, Lee's right. And the thing about it, I know y'all hear about it all the time, and we don't hear about it all the time, but we hear about it some of the time. And certainly it's issues that come up before us, but I got a sneaking suspicion you would find there are lots of people on this planning commission that have their own ideas and, or would have ideas in terms of how to deal with it, where y'all are not spending an exorbitant period of time dealing with this only to come to us with your suggestions. And yeah, we might agree and we might not agree, but just to engage the planning commission in the process itself. And I know it's been talked about in the past, but I don't ever remember there being an outside work session that was set up to deal with this. And you've got all these ideas, these concerns right here. They're a good start. So let's just do it. But I mean, doing it doesn't mean let's talk about it right now and then we'll have a meeting sometime down the road. I mean, we got to just go on and set them and get them done. Golly darn. They don't get done by themselves by any stretch of the imagination. And you guys are doing a great job. I have to give you that. But use us.
And I thought that's the conversation we were having. And what do we need to do? Do I need to send an email or set up a work session?
I think.
But you're giving us this right now, and we're reading it right now. I didn't get it in my package. Was it sent in the package?
Yeah, send an email out, request input from each commissioners. And commissioners, please do respond with kind of your personal, feelings of, just trying to think of after this is done, how it'll be used, good and bad, and try to kind of, give the staff your input on what you think about, the family subdivisions and how we can allow, families legitimately want to have a, kind of areas where their family lives versus people, using this as just kind of an end around.
I thought we couldn't have family subdivisions.
We can't. This is a way to get family subdivision was in quotes, right?
We just call it. We'll have another name for it, Art.
Yeah,
Ken, let me ask you a question. Is the restriction for a municipality within its corporate limits or within its police jurisdiction or both?
Say that again, Art.
Is the restriction on family subdivisions for municipalities included only in the corporate limits, or does it also include the planning jurisdiction?
It would apply to the entire planning jurisdiction. And just to be clear, there's no statute that says cities cannot have or provide an exemption for, quote, family subdivisions. The statutory situation is the legislature expressly exempted family subdivisions as defined by that statute from subdivision regulations by counties. It withheld or did not give that exemption from municipal regulation, so that if you were to try to divine the legislature's intent, you would say, well, it must have intended for family subdivisions not to be exempt from municipal regulation. I'm not telling you that there's a statute that says you cannot have family subdivisions. I'm telling you that's probably the correct interpretation of the statutory structure.
All right, why did then in Baldwin County?
Remember that the city has not put a $900 UV light in cleaning coronavirus out of the air. So we're starting to breathe each other's same air after 2.5 hours. So I love this.
I'm glad I ain't in there breathing it.
So I love this to go out in a email where I could get in my safe air again before I keep, breathing Emily's air in over and over again, or vice versa.
You already got them now. You might as well go drink your Coronas.
Mr. Chairman, can I make a quick comment before we move on?
Sure.
So what I would, to just to try to bring this full circle for the Planning Commission's consideration, remember what I would ask the Planning Commission to do is go back and watch the video of the young lady who came in for an informal review, and she explained the situation facing her family and their request, and compare what they told us then versus what you've seen tonight presented by Hunter. And I hope you'll do that. And then my second thing is, remember, Art a couple months ago said, well, what about the family that has 7 children? Again, I would respectfully request that you contemplate that when you look at what's just been presented to you, because I think that there are potentially some solutions to those requests and those types of situations.
That's why we need to talk about it, because, and there really is no reason to reinvent the wheel. But in terms of utilizing some of what's already been done, for example, in the county, I mean, it's something to talk about, and certainly it should be.
And remember,
and family subdivisions there are limited to specific family members. They don't include Uncle John's half brother 3 times removed by his 4th wife.
Well, but remember, y'all, we're not going to find a solution for everything. You know, 92-year-old Mr. Wasp has 28 children, 26 are surviving, 2 have passed away, so he's got, you know, lineal inheritors. He's in the 30s. So we're probably not going to make a family subdivision to allow for 30 lots on a 10-acre parcel, so we're obviously not going to hit a solution for every single person out there. But please do send that, and let's get some input moving back and forth. And be honest, guys, if you think it's just an end around and that, you know, these are anecdotal cases and not every lot needs to be subdivided, then, you know, say that. You know, you can't make everybody happy. All right. Do we have one more item on the agenda, Hunter?
That's it, Chairman.
I thought we had the,
We did, we still haven't, and Councilman Boone, do you know if they've, I haven't, the industrial board has not, have they resumed meetings? Okay, that's tied to, during the COVID, that zoning change is tied to something the industrial board proposed.
Okay.
And they haven't resumed meetings, so I'd like to talk with them. We kind of got postponed here. So
All right.
we'll just keep that on old business until the industrial board meets again and we have a chance to talk with them.
sounds good. Do I have a motion to adjourn?
So moved.
Do I have a second?
Second.
All in favor, say aye.
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 Who was the second?
Rebecca, Harry.
We're not asking for further